Hi, Bill Bernard, WFB Legal Consulting Incorporated. I just had a meeting with a client. It was related to a business issue, actually a business entity that he wanted to form. However, the discussion got around to living trusts, and he essentially said, I heard about all these good deals on the internet. So and so can do a will, and the will is very inexpensive, and it gets your estate to who you want it to go to when you pass, so forth and so on. And he ended up saying, okay, Bill, what is the difference between a will and a living trust? Well, the obvious differences we all know about, or we should know about, that is privacy by way of a trust. It's not a matter of public record. And of course, the expediency and the tremendous savings and costs that would normally be associated with a probate court. But a will by itself is more than just a document that gets probated. It's a worthless document, in my humble opinion, and here's why. If you die intestate without a will or a trust, you go to probate court, and your estate gets passed to your heirs through intestate succession. If you go to, if you have a will and no trust, you go to probate court. And the distinction is that now your estate still gets probated, but it goes to specifically who you have listed in the will. So my client and I talked about a pour over will, and a pour over will is something that is accompanied with a living trust and all of the documents associated with a trust package: powers of attorney for healthcare, powers of attorney for assets, healthcare directives, trust certification, etc. I'm happy to tell you about all these things if you're interested. However, a pour over will, which goes with a living trust, allows you to petition the probate court for a portion of your estate that was not funded in the trust, but which can be established as having your intent to have it pour over into the trust so it can be funded in the manner that all of the other portions of your estate were. So in other words, you have a piece of property somewhere and you forget to put it in your trust, or you never get around to putting it in your trust. All of your other properties are in your trust. You petition the court, you say it was intent for Mr. So-and-so or Mrs. So-and-so to have this piece of property pour over into the trust and be distributed according to the intent of the trustor. Okay, so that's essentially it. I hope that helps clarify some things. Do not go on the internet and get a will, or just get a will from anybody without getting a living trust. Talk to you soon. Take care. Bye bye.